In this video, we will examine a disturbing pattern where the badge meant to protect becomes a shield for violence. These cases trace former law enforcement officers who crossed a line few expect them to cross, using training, authority, and institutional trust to commit irreversible crimes. James Duckett, State, Florida, 68 years old, death row. James Duckett did not arrive in Mascot, Florida as a man already marked by scandal. In the early to mid-1980s, he was a local police officer, one of the uniformed figures residents associated with order in a small community. On the evening of September 26, 1987, that sense of normalcy fractured. Teresa McCabe, an 11-year-old girl, disappeared while riding her bicycle near her home in Mascot. It was the kind of disappearance that initially sparked confusion rather than immediate panic, a child overdue. A bike ride that lasted longer than expected, a town assuming the situation would resolve itself. But as hours passed, concern escalated. What investigators would later establish is that during this same time window, James Duckett was on duty. He was wearing his uniform, driving his patrol vehicle, and operating under the authority of the badge. According to the conclusions reached by investigators, Duckett used that authority and the automatic trust it commanded to approach Teresa. The encounter did not occur in a hidden or extraordinary setting. It unfolded within the ordinary landscape of a small town, under conditions that would not have immediately alarmed a child or passers-by. The following day, September 27, 1987, Teresa McCabe's body was discovered in a nearby pond. The recovery transformed a missing child case into a homicide investigation overnight. From that moment forward, law enforcement faced an uncomfortable reality. The crime scene did not point outward toward a stranger passing through town, but inward toward someone who understood police procedure, response times, and investigative blind spots. As forensic work progressed through the final months of 1987, evidence began to narrow the focus. Hair recovered from the victim was analyzed using microscopic comparison techniques, a standard forensic method widely accepted in courts at the time. Analysts concluded that the hair was consistent with James Duckett. Investigators also identified witnesses who stated they had seen Duckett near Teresa, approaching her while in his patrol car. Piece by piece, the case shifted from uncertainty to accusation. By early 1988, James Duckett was arrested and formally charged. The list of accusations reflected not only the severity of the crime, but the breach of professional duty. It represented sexual assault of a minor, aggravated homicide, and abuse of authority while on duty. The trial that followed later that year became a focal point for the community and the state. Prosecutors built their case around two central pillars: witness testimony placing Duckett at the scene and forensic hair evidence linking him to the victim. The defense, in turn, challenged the reliability of hair comparison analysis, arguing that the science was overstated and lacked the precision jurors were being led to believe it possessed. Despite those objections, the jury convicted Duckett in 1988, and the court imposed a sentence of death. For many cases, a conviction signals closure. In the Duckett case, it marked the beginning of a decades-long legal battle. From 1989 through the 2000s, Duckett filed multiple appeals, repeatedly contesting the scientific validity of the hair evidence and alleging procedural errors during his trial. These appeals unfolded alongside a broader shift in forensic science as researchers and courts increasingly questioned the reliability of microscopic hair analysis. A method once treated as near conclusive, later criticized for subjectivity and lack of statistical grounding. Yet, despite evolving scientific standards, appellate courts consistently upheld Duckett's conviction and sentence, ruling that the original proceedings met the legal thresholds required at the time. As of 2025, James Duckett remains on death row, with no execution date scheduled. His case continues to surface in legal scholarship, reform debates, and true crime analysis, not only because of the crime itself, but because of what it represents. It is cited in discussions about outdated forensic methods, the unique dangers posed when law enforcement authority is abused, and the irreversible consequences of capital punishment in cases shadowed by evidentiary controversy. The Duckett case forces an uncomfortable reckonings when the system places its trust in a badge. What safeguards truly exist when that trust is betrayed? And how certain must we be before the state carries out its most final sentence? Manuel Pardo Jr., State, Florida, 56 years old, execution date 111/2012. Manuel Pardo Jr. did not begin his adult life as an outsider to the law. In the late 1970s and early 1980s, he wore the uniform of authority, first with the Florida Highway Patrol and later with the Sweetwater Police Department. That belief crystallized in March 1986. In Miami-Dade County, the first killing attributed to Pardo occurred with little initial fanfare. The victim had ties to drug activity, was shot with a handgun at close range, and appeared to be the target of a deliberate execution rather than a spontaneous act. At the time, it fit a pattern familiar to investigators in South Florida: violence within criminal networks, quickly absorbed into an already crowded caseload. What no one recognized yet was that this was not an isolated incident, but the opening act of a carefully paced sequence. Over the next 3 months, from March through June of 1986, 9 people were killed. The similarities were impossible to ignore in hindsight. Most of the victims had criminal histories or connections to drug trafficking. Each killing bore the marks of control and intent, rather than chaos. Some of the bodies displayed a chilling signature: ears removed, a symbolic gesture investigators would later interpret as a form of trophy-taking. During this same period, Pardo kept a personal journal, meticulously recording details of the killings. In those pages, he did not describe himself as a murderer. He described himself as a vigilante, a self-appointed executioner tasked with cleansing society of those he deemed irredeemable. This was not violence driven by impulse or desperation. It was methodical. Pardo used his law enforcement training to anticipate investigative responses, to choose locations and timing that minimized immediate suspicion, and to blend into the background of a city accustomed to violence. His familiarity with police procedure allowed him to move confidently, even arrogantly, through the aftermath of each killing. He believed that his understanding of criminal behavior and his prior badge placed him on the same moral side as the officers who would eventually be assigned to hunt him. By mid-1986, that confidence began to unravel. Detectives noticed patterns that could no longer be dismissed as coincidence. Ballistics evidence linked multiple crime scenes. Witness statements and information from within criminal circles began to converge on a single figure who did not fit the profile of a typical street-level suspect. In June 1986, Manuel Pardo Jr. was arrested. The man who had framed himself as an invisible force of order was suddenly exposed to the full weight of the system he believed he had mastered. During interrogation, Pardo showed little remorse. He did not deny responsibility in the way most suspects do. Instead, he defended his actions. He spoke openly about cleaning up society, positioning himself as a necessary corrective to what he viewed as institutional failure. This posture would define every phase of his legal journey. From the beginning, Pardo was not interested in mitigation or redemption. He was interested in justification. The trial began in 1987 and quickly became as much about ideology as evidence. Prosecutors presented the journal entries, the ballistics matches, and a narrative of premeditated violence rooted in a distorted sense of moral authority. The defense struggled to counter the volume and coherence of the evidence. At times, Pardo represented himself or disrupted proceedings, using the courtroom as a platform to reiterate his vigilante beliefs. His behavior reinforced the prosecution's argument. This was not a man who lost control, but one who believed control entitled him to kill. In 1988, the verdict was delivered. Manuel Pardo Jr. was convicted on 9 counts of first-degree murder and sentenced to death. For the families of the victims, the sentence marked accountability. For legal observers, it marked the beginning of a long appellate process that would test the limits of tolerance for ideological violence carried out under the shadow of former authority. On December 11, 2012, at Florida State Prison, Manuel Pardo Jr. was executed by lethal injection. No official statement of remorse was recorded. The case closed more than 26 years after the first killing, but its implications endured. Pardo's story remains a stark warning about what happens when authority, ideology, and unchecked certainty collide. It raises an enduring question at the heart of true crime and criminal justice alike, when someone trained to enforce the law decides to rewrite it. How many lives are lost before the system recognizes the threat? Jeffrey Hodge, State, Ohio, 56 years old, sentenced to life. Jeffrey Hodge entered law enforcement quietly, without the warning signs that later hindsight would search for. In the late 1980s and early 1990s, he worked as a police officer for the University of Toledo Police Department in Ohio, a role designed to provide safety within an academic environment. On the night of January 14, 1992, that trust was shattered. Melissa Herstrom, a 19-year-old university student, disappeared while on the University of Toledo campus. At first, there was confusion rather than immediate alarm. College campuses are fluid spaces, and students move in and out of dorms, libraries, and parking areas at all hours. But as the night passed with no contact from Melissa, concern began to harden into fear. What investigators later established was that during this same time window, Jeffrey Hodge was on duty. He was not an outsider lurking in the shadows. He was part of the institution meant to protect students like Melissa. According to the conclusions reached by investigators, Hodge used the authority of his position to approach Melissa. A campus police officer asking questions or offering assistance would not have triggered suspicion. That authority allowed him to control the interaction, to limit her ability to resist, and to move her away from public areas without raising immediate alarm. The crime, as reconstructed by prosecutors, was not impulsive. Melissa was restrained with handcuffs, standard police equipment, effectively removing her capacity to flee or defend herself. She was taken away from populated areas of campus, into isolation. There, Hodge fired 14 shots, an overwhelming use of force that left no ambiguity about intent. The following day, January 15, 1992, Melissa Herstrom's body was discovered. The details were stark and devastating. She was still handcuffed. Investigators found no meaningful signs of defensive wounds, a detail that reinforced the conclusion that she had been restrained and controlled throughout the encounter. The scene itself raised immediate red flags. Handcuffs are not items commonly used in civilian crimes. They pointed directly toward law enforcement involvement. By mid-January 1992, the investigation narrowed with unusual speed. Ballistics and equipment analysis showed that the ammunition and restraints were consistent with police-issued gear. Witness accounts and patrol records placed Jeffrey Hodge as the last officer known to have contact with Melissa. Unlike many cases where suspects are identified through long chains of circumstantial evidence, this case collapsed inward. The threat was not hidden beyond the perimeter of the campus. It had been embedded within its security structure. By the end of January 1992, Jeffrey Hodge was arrested. The charges were severe and specific aggravated murder, kidnapping, and abuse of power while on duty. The inclusion of abuse of authority reflected more than legal classification. It was an acknowledgement that the crime could not be separated from the role Hodge occupied. This was not merely a homicide. It was an act enabled by institutional trust. The trial in 1993 focused heavily on that breach. Prosecutors emphasized the physical evidence, the handcuffs, the number of shots fired, the controlled nature of the crime. 14 gunshots were not presented as excess alone, but as proof of deliberate intent. The courtroom narrative made clear that Melissa Hurstrom had been rendered powerless before the first shot was fired. Hodge did not deny pulling the trigger, but he failed to provide any explanation that justified or mitigated his actions. His silence on motive only deepened the perception of calculated violence. When the verdict was delivered in 1993, the court imposed a sentence of life imprisonment without the possibility of parole. It was a definitive judgment, reflecting both the gravity of the crime and the circumstances under which it was committed. The sentence acknowledged that this was not a case in which rehabilitation or future release could reasonably be contemplated. From 1994 onward, Jeffrey Hodge entered the long, static phase of incarceration within the Ohio prison system. Over the years, appeals were filed, as is common in serious felony cases, but none succeeded in altering the outcome. No procedural failures were deemed sufficient to overturn the conviction. No new evidence emerged to soften the legal conclusions. The case settled into permanence. In 2021, nearly 3 decades after the crime, Hodge sought parole. The request was brief in its outcome, if not in its implications. The parole board denied the application, citing the exceptional severity of the offense and the profound abuse of police authority involved. The decision reinforced a principle central to the case. Some violations of trust are so complete that they permanently sever any claim to reintegration. As of 2025, Jeffrey Hodge remains incarcerated at Marion Correctional Institution in Ohio, serving a life sentence with no parole date scheduled. His case continues to be referenced in discussions about campus safety, police oversight, and the risks inherent when authority goes unchecked. Beyond the legal record, the story of Jeffrey Hodge forces an enduring question onto the public conscience. When protection becomes control, and control becomes violence, how many safeguards truly exist to stop it before it's too late? Richard DiGuglielmo, State, New York, 60 years old, released. Richard DiGuglielmo's story begins in a place that rarely attracts scrutiny until something goes wrong. In the late 1980s and early 1990s, he served as a police officer with the New York City Transit Police, a force tasked with maintaining order in one of the most complex public transportation systems in the world. In 1996, a confrontation outside a small family-owned store in New York changed everything. The incident did not begin as a violent crime, but as an argument over a parking space, one of the most ordinary and combustible disputes in an urban setting. What unfolded next would transform a routine disagreement into a fatal encounter. During the argument, Richard DiGuglielmo drew his firearm and shot Charles Campbell, a black man and the owner's relative, outside the store. Campbell died from his injuries. Almost immediately, the case ignited public attention, not simply because of the death itself, but because of who was involved. A police officer had killed a civilian. The civilian was black, and the justification offered, self-defense, fell into a legal and moral gray zone that New York had been struggling to define for years. From the earliest moments after the shooting, the narrative fractured. DiGuglielmo maintained that he feared for his life and acted to protect himself. Investigators, however, were faced with conflicting witness accounts. Some described Campbell as aggressive, Others questioned whether the situation posed a lethal threat at all. The dispute raised uncomfortable questions about escalation. Was deadly force necessary, or had a trained officer allowed a minor conflict to spiral into a fatal outcome? These questions were not abstract. They shaped every stage of the investigation that followed. Later in 1996, after reviewing evidence and testimony, prosecutors charged Richard DiGuglielmo with second-degree murder. The decision to bring such a charge against a police officer underscored the seriousness with which the case was being treated. It also guaranteed that the trial would be closely watched, not just as a determination of guilt or innocence, but as a test of how the justice system handles violence committed by those sworn to uphold the law. The trial in 1997 unfolded against a backdrop of heightened racial tension and growing scrutiny of police use of force. Prosecutors argued that DiGuglielmo's actions went far beyond the boundaries of lawful self-defense. They emphasized the nature of the argument, the lack of a clear and immediate lethal threat, and the responsibility of an officer to de-escalate rather than inflame a confrontation. To the prosecution, this was not a split-second decision made under unavoidable danger, but a conscious choice to use deadly force in a situation that did not require it. When the verdict was delivered in 1997, the court convicted Richard DiGuglielmo and sentenced him to 20 years to life in prison. The decision reflected a conclusion that the shooting crossed the line from defense into criminal conduct. For supporters of the verdict, it was proof that police officers could be held accountable under the same laws as civilians. For critics, it raised concerns about whether DiGuglielmo had been judged not only for his actions, but for what he represented in a broader social conflict. From 1998 through the 2000s, DiGuglielmo served his sentence within the New York State prison system. During this time, he pursued multiple appeals, challenging both the legal interpretation of self-defense and aspects of the trial process. None succeeded in overturning the conviction. The case settled into a long period of relative quiet, resurfacing periodically in legal discussions about self-defense standards and police conduct, but largely absent from public attention. That changed again in 2018, when the New York Parole Board approved DiGuglielmo for release. The decision reignited controversy. To some, parole reflected the system functioning as designed, allowing for review after decades of incarceration. To others, it felt like a reopening of unresolved wounds, particularly given the racial dynamics of the original case and the ongoing national debate over police violence. On January 7, 2019, Richard DiGuglielmo was released from custody. As of 2025, DiGuglielmo remains free, his sentence completed under the terms of parole. Yet the case has never truly faded. It continues to be cited in discussions about where self-defense ends and criminal liability begins, especially when the person pulling the trigger is a trained officer. It also remains part of the broader conversation about race, authority, and accountability in the American justice system. At its core, the case of Richard DiGuglielmo leaves a lingering question that resists easy answers. When an officer claims fear, who decides whether that fear justifies a death, and how much trust should society place in that judgment? Joseph Kent McGowen, State, Texas, 60 years old, sentenced to life. Joseph Kent McGowen built his adult identity inside the structure of law enforcement, a place where authority is reinforced daily by uniform, procedure, and institutional loyalty. Everything began to fracture in early 1992. Susan White, a woman living in Harris County, accused him of harassment and intimidation. The complaint moved through internal channels, the very mechanisms designed to protect both officers and civilians. On paper, it was just another allegation awaiting review. In reality, the complaint threatened not only the job of McGowen, but the authority that defined him. According to investigators, the filing of that complaint triggered anger, fear, and a growing sense of vulnerability. The balance of power between officer and civilian shifted, and the relationship between McGowen and Susan White became increasingly tense. Later in 1992, Susan White was shot and killed. The date itself has never been widely publicized, but the outcome was immediate and irreversible. Joseph Kent McGowen was the man who pulled the trigger. In the moments that followed, he did what his training had prepared him to do, not to preserve life, but to control the narrative. Investigators later concluded that McGowen staged the scene to resemble a case of lawful self-defense. His initial report described Susan White as a threat, framing the shooting as a necessary response to danger. On its face, the account fit a familiar pattern: an officer confronted with a hostile individual, forced to act quickly. For a time, that version held. From 1992 onward, the case lingered in a gray zone of unresolved suspicion. As investigators revisited the evidence, inconsistencies began to surface. Physical findings at the scene did not fully align with McGowen's account. More troubling was the timeline: the documented complaint Susan White had filed months earlier. What initially appeared to be an isolated shooting began to look like retaliation. Over the years, the case underwent internal reviews and renewed scrutiny, each pass revealing more friction between McGowen's statements and the facts. Public pressure grew as the idea took hold that a woman who had dared to accuse a police officer ended up dead, and that the system had hesitated to confront that possibility. By 2002, the accumulated evidence and scrutiny reached a tipping point. Prosecutors formally charged Joseph Kent McGowen with murder. Their theory was direct and unsettling: the shooting was not self-defense, but revenge. According to the state, McGowen acted to silence a complainant and protect his career, exploiting his training and authority to disguise the act as justified force. The trial forced jurors to confront a deeply uncomfortable scenario: not a split-second mistake, but a calculated abuse of power rooted in fear of accountability. When the verdict was delivered in 2002, McGowen was convicted and sentenced to 20 years in prison. It was not a life sentence, but it carried symbolic weight. The court acknowledged the severity of the crime while operating within Texas sentencing law, which allowed for parole eligibility after a portion of the sentence was served. For some observers, the sentence felt restrained given the circumstances. For others, it represented a rare moment in which a law enforcement officer was held criminally responsible for killing a civilian who had challenged him. McGowen entered the Texas prison system in 2003. Unlike cases that dominate headlines through endless appeals, his incarceration unfolded quietly. By approximately 2007, he became eligible for parole under state guidelines. What happened next remains largely opaque. Public records do not clearly indicate whether parole was granted, denied, or delayed. There are no widely reported hearings, no confirmed release dates, no definitive statements about his current custodial status. By 2025, McGowen may have completed his sentence, or may have been released earlier under parole supervision. The lack of transparency itself has become part of the story. At its core, this is not just a story about a single officer or a single victim. It is a warning embedded in the mechanics of power. When authority is challenged from below, and the challenge is routed back through the same hierarchy that granted that authority in the first place, the consequences can be fatal. The unanswered questions surrounding McGowen's current status only deepen the unease. If justice is meant to deter abuse, what message is sent when the final chapter remains hidden? And how many others have chosen silence over survival after seeing what happened when Susan White spoke up? Paul Durousseau, State, Florida, 55 years old, sentenced to life. Paul Durousseau's path into violence did not begin in chaos or marginalization, but inside one of the most disciplined institutions in American society. In the early to mid-1990s, he served in the United States Army as a military police officer, a role built around authority, control, and enforcement. The first killing attributed to Durousseau occurred in 1997 in Georgia. The victim was a young woman, targeted not at random, but because she was vulnerable. Investigators later concluded that the attack involved sexual assault, followed by strangulation, a method that requires prolonged physical control and close contact. At the time, the crime was treated as an isolated homicide, tragic but unexceptional in a system flooded with similar cases. No connection was made to Durousseau, and no pattern was identified. Over the next 6 years, from 1997 to 2003, the violence continued. At least 7 women were killed across Georgia and Florida, though investigators believe the true number may never be fully known. The victims shared critical similarities. They lived on the margins, lacked consistent protection, and were easy to overlook once they disappeared. At least 2 of the women were pregnant, a fact that later weighed heavily in court as an aggravating factor. For years, law enforcement chased fragments instead of a whole. Each homicide was boxed into its own file, its own timeline, its own local limitations. The absence of early linkage allowed Durousseau to move freely, operating across state lines without raising alarms. This is where his background mattered most. He understood investigative blind spots. He knew how cases stalled, how evidence degraded, how interagency coordination failed. What looked like luck was, in reality, structural advantage. That advantage collapsed in early 2003. Durousseau was arrested in Florida in connection with a specific murder, one that finally produced the forensic leverage investigators needed. DNA evidence tied him directly to the crime. Once his genetic profile entered national databases, past cases began to align. Patterns that had once been dismissed as coincidence now formed a clear trajectory. State and federal agencies coordinated, re-examining unsolved murders through a new lens. By mid-2003, Paul Durousseau was officially identified as a serial killer responsible for a string of murders stretching back to 1997. Later that year, Durousseau stood trial in Florida. The prosecution's case was methodical and overwhelming. DNA evidence anchored him to multiple crime scenes. Forensic experts testified about the consistent methods used across the killings. Prosecutors emphasized the escalation, the number of victims, the sexual violence involved, and the pregnancies that amplified the harm beyond individual lives. This was not framed as a momentary lapse or a crime of passion. It was presented as sustained, deliberate predation. In 2003, the jury returned a verdict of guilty, and Durousseau was sentenced to death. The ruling appeared definitive. The state had identified, prosecuted, and condemned a serial murderer. For the families of the victims, the sentence promised finality. For the justice system, it marked closure. But the case was not finished. From 2004 through the mid-2010s, Durousseau lived on Florida's death row, filing appeal after appeal. These challenges did not center on innocence. Instead, they focused on procedure, specifically, the way Florida juries weighed aggravating factors in capital sentencing. While many of his appeals were rejected, the legal ground beneath death penalty cases in Florida was shifting. In 2017, those questions reached Durousseau's case. The Florida Supreme Court vacated his death sentence, ruling that the original jury process did not meet updated constitutional standards. The decision was procedural, not moral. It did not dispute the evidence or the verdict. It simply acknowledged that the process used to impose death no longer met legal requirements. Durousseau was removed from death row and scheduled for resentencing. That resentencing occurred in 2021. This time, the outcome was permanent in a different way. Paul Durousseau was sentenced to life in prison without the possibility of parole. The death penalty was removed from the equation entirely. For some, the change represented a system correcting itself. For others, it felt like a dilution of justice, an administrative revision that did nothing to restore what had been taken. As of 2025, Paul Durousseau remains incarcerated in the Florida prison system, serving life without parole. He will never be released. At its core, the Durousseau case forces a confrontation with uncomfortable realities. Training does not guarantee restraint. Authority does not prevent predation. And justice, even when delivered, is rarely final in the way victims' families are promised. The question that lingers is not only how Durousseau was stopped, but how many years he was able to operate before the system learned to see him, and how many warning signs were never recognized until it was far too late. These cases do not end neatly with convictions or sentences. They leave behind questions about accountability, oversight, and how easily authority can be weaponized when warning signs are ignored. From death row to parole boards, each outcome reflects both punishment and systemic failure. As the stories fade from headlines, their implications remain. Do you believe these outcomes represent justice, or proof that the system still protects its own?